Hey guys, it's a Sunday and I've been sitting here thinking about how I'm going to talk to you about what I'm going to talk to you about. But what I want to talk about is kind of a trend I'm seeing in how the courts right now are dealing with summary judgment motions. And when I say courts, I'm speaking specifically of California courts because that's where my experience and knowledge base is. But I would not be surprised to find out that this is going on in the rest of the country. And I'd be interested to see if other jurisdictions are dealing with this as well. So quickly, I'm going to have a separate video on summary judgment motions in general, what they are, how to beat them, and all that sort of thing. But just to have it here in this video too, I'm going to quickly summarize that. A summary judgment motion is it's a dispositive motion, which means if it's decided against the plaintiff, then the case is over. That it effectively nullifies the plaintiff's chance of continuing on and making his or her claim heard by a jury or before a court. If you're the plaintiff and you lose a summary judgment motion, the case is over. There's judgment entered against you and you probably owe costs and fees, maybe some other stuff to the defendant because the defendant has technically won. It's the same as if there was a defense verdict. And if you win as a plaintiff, you win the opportunity to continue trying to convince people that your case has merit. So the way you win is you have to show the court that there is a difference of fact that has to be decided by a jury before we can decide anything legally, anything based on the law. So MSJs are about facts. MSJ is short for summary judgment, motion for summary judgment. It's about facts. The facts are the most important part, and I don't know how many times I can say this, but facts have to be your foundation. You have to have a foundation of facts, and you have to have a lot of facts. If you think you have too many facts, you probably have barely enough. So usually in MSJ, the defendant bringing the motion, it says basically there's an element of your claim. Say you claimed negligence, so there's an element of negligence that you can't possibly meet based on the evidence we have in this case so far. And then the plaintiff's job is to come in and say, that's not true. I have all of this evidence. Here's all these facts, and here's the supporting evidence for them, okay? So it's super important for plaintiffs to win these. I've been practicing about 10 years, a little over 10 years. In that 10 years, I probably have averaged about 10 motions for summary judgment a year. And in the past year, it's been a whole lot more. I've been doing a lot because, of course, I do the ghostwriting. So these are not my cases. I'm helping or consulting with other attorneys who are trying to defeat these motions to get them denied. Before COVID, pre-COVID, I think I lost a total of 3 summary judgment motions, and I probably should have lost all 3 of those, except for one, which is my white whale, and I will always be upset about. In the last year, I'm probably losing 40 to 50% of the summary judgments I work on, and this is not because I've gotten worse at opposing them, although for a while I really told myself that that's what was going on, is that I wasn't invested enough, I wasn't trying hard enough, I wasn't smart enough, or I was losing my touch or something. That's not true, because the trend, and I've talked to a bunch of attorneys about this, the trend is that the courts, which are extremely backed up thanks to the pandemic and the closures that have happened and all the trials that are bottlenecked there now, they're trying to clear their docket. So it makes sense when a case is questionable and it seems like a jury is not super likely to issue a verdict in favor of the plaintiff, that courts are like, let's just take this shortcut. I don't like this case. It takes a case off my docket. Worst case scenario, they'll appeal it and I have to deal with it in 2 years. So kind of that's the attitude of courts right now, which super sucks for plaintiffs for a couple of reasons. One, even if you appeal and you're validated and the court is, admonished for granting summary judgment when it shouldn't have, that's not going to happen for 2 years, and a plaintiff has to wait another 2 years to have their day in court and to get compensation for their claims. The other way it sucks is at the appellate level, they get to the appellate level, and then the appellate level requires a settlement conference or a mandatory, mediation of some sort, alternative dispute resolution, and the defendant who originally brought the motion sees that there's a risk on appeal, right? So they see that it's very possible the appeal could go against them and they're going to end up owing a lot of money. So they'll come to the mediation or the settlement conference at the appellate court level. They'll come with a little money, not a lot, maybe like a third of what the case is really worth. And the plaintiff sees the risk, right? Like that the appeal could not get granted and they could get nothing, and then the case settles. So now the case, which should have resolved for a higher level, to make it a fair settlement, it should have been at one level, and now they're getting a third of that. And that's because the trial court is so backed up and busy, it doesn't have time to actually think about or consider these things in reality. So again, there's not a lot I can do about the trends. The courts are going to do what they're going to do, and judges are going to do what they're going to do. And there's not really anything we can do about that. The only thing we can do is make sure we're listing and bringing enough facts in opposition to these summary judgment motions. It's not enough that we're right on the law. Summary judgment motions are not about the law. They seem like they're about the law because there's a lot of analysis that goes on, but there's only that analysis because of the facts, right? So we need to bring as many facts as possible. One time, a week ago or so, maybe 2 weeks ago, I flipped the judge. The judge issued a tentative ruling to grant summary judgment motion. And this summary judgment motion was on the element of breach. It wasn't even on duty or causation or some of these harder elements to prove, which can be questions of law when there's no dispute of facts. This is actually breach, which case law tells us is a question of fact for a jury to decide. And this court was going to grant summary judgment, even though the only issue raised was that there was no breach. Luckily, at the hearing, the judge was very willing to listen to me. I pulled down the fact from the statement of facts, from the separate statement, and I said, look, here's the specific fact. This fact was not opposed by, or not disputed by the defendant, and even if it was, great, that would be better because then we'd have an actual dispute of fact. But here's evidence. If a jury believes it, a jury could reasonably say that there's negligence here, that he breached a duty. And I said, here's the fact. And then I read out into the record the testimony on which I based that fact, right? So when you do the summary judgment, you say, here's the fact, and then you have to give the evidence that supports that fact. So I read out the testimony and the evidence that supported that fact, and the court reconsidered their tentative and agreed to flip it and denied the summary judgment motion. And really, that's the only way you can do it. You've got to have those facts. And honestly, you never know quite exactly what angle the court's going to take or what angle the defense is going to take and how to distinguish it. And oral argument is scary and things can go awry, but if you can stay focused on the facts, you'll always have a good place. You'll always be talking from a solid foundation. And again, I hate to be repetitive, but this is what we do as writers. We've got to lay out the facts. And even when I had written that opposition in my statement of facts, I thought, all right, this is pretty clear. And then when I went back to prepare for oral argument, I looked at it and I thought, man, this could have been broken up in two different facts. This could have been, I could have laid this out better. I could have gone through the testimony and been more detailed, and that would have made it easier for the court to rule in my favor. So I'm going to make a pledge from now on to get even more detailed and granular with the facts. And I don't care if my statement of facts, I used to try to keep my statement of facts short, but I don't care anymore. I'm going long. I'm going to make my statements long. I'm going to break it down, and I'm going to build that foundation. And hopefully the courts will start listening to us if we can band together on this. So, okay, that's all I wanted to say today. MSJs are really tough, but the secret to them is always in the facts.